Hello, I'm Jack Fine, managing partner of Fine, Farkash and Parlapiano, a Gainesville, Florida personal injury law firm. One of our more noteworthy cases, and it was done early in my career, was the case of Graham v. Vann, which can be found at 394 Southern 2nd, 176. In Graham, we were approached because the conditions at our local state prisons, Florida State Prison and Union Correctional Institute, were not good, and there were murders happening at a very, very high rate. And the reason why we were approached is because we were part of the public defender's office and we had to represent these murder cases, and they were very, very difficult cases to do because we're representing convicts who were already in a high security Florida prison because of their conduct, and they were tried in a venue, namely Bradford or Union counties, where the juries were composed of families who were affiliated with correctional officers who were working in the prisons. The goal of the case was to provide better conditions in the prisons so that murders weren't happening at such a high rate. We wanted to protect our potential clients. And what we did is we filed an action against the governor of the state of Florida, who at that time was Bob Graham, and Louis Wainwright, who was the head of the Florida prison systems. You may remember the famous Gideon v. Wainwright case from many years ago, which established the right to counsel. So we sued on behalf of a bunch of prisoners, the governor and the head of the corrections department, and the eventual result in the case was that correctional officers got increased pay, they got better working conditions, the prisoners were protected because there were more systemic sweeps for weapons inside the prison, so there weren't as many murders. The case ended up being successful. It was appealed after the circuit judge, Buzzy Green, ruled in our favor, and I eventually made an argument in front of the First District Court of Appeal, essentially taking the judge's side, saying the judge was correct in what he did by ruling for us and imposing these particular conditions on the prison, forcing the state to do what they should have done all along, which is to provide civilized conditions for incarceration. I want to mention that the case came about after a similar earlier case called Nebor v. TL, where we represented juveniles in the juvenile detention center here in Gainesville. And in that case, similar to Graham v. Vann, we were trying to improve the conditions of incarceration. For the juveniles, the state agency had no classification system. In other words, when a child is arrested, let's say for being a runaway, he was placed in a facility in potentially a cell or a room with, let's say, an older, more experienced sexual batterer or armed robber. As a result, the status offenders, the kids who ran away or didn't want to go to school, were being victimized during their incarceration by older, more violent juvenile offenders. In the Nebor case, a circuit judge, and it was the same Judge Green that we had in the later Graham v. Vann case, imposed a strict set of conditions on the state agency for juvenile rehabilitation and incarceration, saying, you can't do this, you can't put a runaway in the same cell with an armed robber or a sexual batterer. We won both of those cases. And as a result of winning those cases, we like to think that conditions were improved. One more story I will tell about these cases is after we filed the Graham v. Vann lawsuit, my boss and I, and my boss at the time was Alan Parlapiano, he was the constitutionally elected public defender for the 8th Judicial Circuit, we were called up to Tallahassee. I was like 1.5 years out of law school. I'd never even been to Tallahassee, and we're called into the office of the State Attorney General, a man named Jim Smith. And Attorney General Smith said to my boss, Alan Parlapiano, and me, you can't do this. you're a state employee and you're suing Governor Graham. You can't sue the governor. I want you to stop this. I want you to dismiss this case. Well, Alan Parlapiano, to his credit, said, no, we're not going to do that. We are going to remain dedicated to our clients and try to improve the conditions for both the correctional officers and the inmates. It was an eye-opener for me having the Attorney General tell me I had to dismiss this case and my boss saying, no, we're not going to dismiss the case. And it was great when we eventually won the case in conditions. We won both cases. We improved conditions for both the juveniles in the local juvenile detention center and for inmates at Florida State Prison and incarcerative facilities throughout the state. We hope this information has been helpful to you. If so, we would ask that you follow us on social media and subscribe to our YouTube channel. Thank you very much.